It sounds like it comes down to a suit for partition because no matter how you get there, at the end of the day, if two or more people own a piece of real estate and you cannot come to a decision about keeping or selling, that it would go in the direction of a suit for partition. Is that correct?
I think you're right. I think the most important part of this text is that the two sisters own mom's home. Mom has passed away. She wants to know what happens when one wants to sell and the other one doesn't want to sell.
Exactly.
And sometimes that happens, and there is a remedy out there that whenever there's two or more owners of property, any one of them can force the sale through a suit for partition. There is no defense to it. The court will order that the property to be sold, and from the sale proceeds, by the way, the lawyer that you hired to pursue that suit for partition will be paid out of that sale proceeds. So as it ends up, the other owners of the property are actually paying the attorney to bring that lawsuit.
Exactly.
So
Correct.
that's a great remedy. Now, Chrissy and all, I've been a lawyer for over 40 years, and when somebody comes to me with this situation, I said, typically our step number one is to write a letter to the other property owner and say, look, I represent your sister. She wants this property sold. You got to cooperate with us to find a realtor to list it, to sell it. If you don't, we're going to bring a suit for partition. And by the way, if we have to do that, you're going to end up paying for half the attorney's fees and court costs.
Correct.
And usually at that point in time, they realize the gig is up and there's really no choice but to sell it or buy out the sister if you can afford it.
Correct. And I think that sometimes I'm sure when people are listening, you may have heard this concept before, or if you have not. But either way, I think it's important for people to understand the basis for this, because it may seem, well, that's harsh, or why is it that way? Here in Florida and in most states, the concept is that no one can hold on to real estate. That's the basis for this. It's a restraint from alienation is the legal term. And the idea being is that for whatever the reason, whether two people, siblings, can't agree on one to sell or one to keep, or whatever the circumstance, including families wanting to keep property for generations and generations, if there's any discrepancy on keeping or selling, it is that the remedy by law is the opportunity where then you have to do a suit for partition, meaning that it goes to what you were saying, that if that type of lawsuit goes before a judge, they have to say that then it would be sold.
Exactly. And by the way, back in the old days, when people own acreage, if a suit for partition, if two people own 10 acres, the court had the ability to literally divide it and give each party 5 acres. These days, you can't divide a house down the middle, which is what most people own. So therefore, the only remedy is to be sold.
Well, I think, but you bring up a good point. If it is acreage, it is still possible to do that. Mm-hmm. However, obviously you cannot do that with a house. More than likely today, most judges will go in the direction of selling. However, if there is a feasible way to divide land only, that could still be a possibility.
Yeah, as long as they come out with 2 equal parcels, they both got access to roads, to water, electric.
Exactly.
That would be the key there.
Absolutely.